Greetings. Thank you for being with us. I am Alex Cafero, as usual, your Law Podcast host. I'm an advocate of the High Court of Uganda. But again, I need to disclaim from the onset that, ladies and gentlemen, this podcast is not a substitution for legal advice. You still need to seek professional legal advice, and like I always say, from professional and authorized lawyers. How do you tell they are professional lawyers? They always have a Uganda Law Society ID with their number, with the details of Uganda Law Society. You can call Uganda Law Society and confirm that Mr. Cafero Alexander is an authorized lawyer to represent me in the courts of law or to do any legal work. Two, they have what we call practicing certificates, and they're always displayed in their offices. So when you go to a lawyer's office, look around, look behind the lawyer. It should be displayed where you can see it, such that you can tell and you can read, hey, that is Cafero Alexander. It's important, ladies and gentlemen. Otherwise, you must avoid quack lawyers. You will get ill advice. You will be ill advised, and you may end up in problems. It's very important that you give your money or instruct a proper lawyer like me. Okay, there are so many other lawyers. I can mention them. There are so many. So look out for professional lawyers. So for the Law Podcast, we make sense of the law. We make you understand. We help you understand the legal principles. I know my non-lawyer friends have always told me that legal principles are abstract. Why do you guys make things hard? Okay, it's not us. It's the members of parliament who make the laws. But I don't know why they make it in that language. It's called legal language. It's a bit hard. But don't worry. We are here to make it simple. Now, today I want to talk about what happens when a person dies, leaving behind property. In our earlier podcast, we had talked about it. Today I want to zero down on something called a will. I am sure a majority of you have heard of a will. The word a will comes from willing, wishing. Things that the owner of that property wishes to be done to his or her property upon death. So that's what's called a will. A will. So, a will has to be written in a certain way. The law provides for how it must be written. Not every document qualifies as a will. In fact, I am sure you've heard people going to court and their wills are challenged. Their wills are cancelled. Their wills are rejected because the court has found out that those wills were not made in accordance with the law. So it's important. And for that reason, you need to seek out a lawyer to guide you. Don't take chances. And it's something easy. And it's also not true that when you make a will, you're sending yourself to the grave. That's not true. Actually, a will is a proper way of carrying on, because then you know that even when I die, you see, we all know that we're going to die. What we don't know is when it's going to happen. So a will is some sort of comfort and confidence that when you die, things are going to be done in a way that you want. So, most importantly, the will must be signed by the person making it. Yes. Signing does not necessarily mean these signatures. It can be a thumbprint. They can be initials. I'm Cafero Alexander. I can just initial it KA. Every page, KA, 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 KA. You see. But it must be owned by the maker. That's the essence. Otherwise, how would you tell that this document was written by Mr. Cafero? No. So it must be written by will. A will must be witnessed by two people. Two. Can be more, but not less than two. And for us, in law, it's called attestation, but there's no reason why you need to know the word attestation. What is important is that it must be witnessed by two people. And those two people must have seen the will maker, must have seen the person making the will. They must have seen that person signing. It's important. they must have seen that person making will. And for that will to be valid, those two people must testify. One of them must testify in court. Now, the will must distribute the property. You see, the law does not allow property to be undistributed for more than 21 years. So, your will must mention you, must describe you, the person making it. It must describe your property. It must describe how you want that property to be distributed, to whom. Even if you have a billion things, you might give one to one and give the rest to another person. 99% to one and 1% to the other. Yeah, that's good distribution. It's good enough. That's your wish. That's what you wanted. Yeah, so a will has to be written by the maker, has to be signed by the maker, has to be witnessed by two people and above. Now, I have said the will must be written, but there are people who are willing to make a will, but they can't write. Now, that person must dictate the terms of that will, the contents of that will, to another person who writes them, or who writes that will in the presence of the will maker. So Kafero Alexander, let's say, contracts a condition that cannot allow me to hold a pen or type, but I can talk. So I call Kevin. Kevin, come here. I am going to dictate what I want you to write for me. So even if Kevin is the one writing, that will is considered as Mr. Kafero's will, because Kafero is seeing Kevin writing what he is dictating to him. So that is will making, that is making of will. It does not have to be that Kafero wrote. Now, people have always come up and challenged. We said, no, that's not the handwriting of the maker. He's not the one who signed. All those issues always will occur, but the evidence always comes up in court to identify the handwriting, to identify the signature, to identify who was there, did they see the person, and so that's how a will is accepted. But for it even to get to that point, it must qualify to be a will. So when there is a will, the court will grant what we call letters of probate, or what we call probate. Letters of administration are granted where a person dies without leaving a will. And that's the most common court authority. You see, letters of administration are court powers, a court authority given to you by court. Now, for a will, you get probate. You present your will. That will is verified to have satisfied the conditions I've mentioned above, and then the court can grant you what we call probate. The person who receives the probate is the person we call an executor. So the executor is the one going to implement the will, to implement the terms in the will. An administrator is for a person who died without leaving a will. This one is the executor. They're the same, but when you hear those terms, it means that this one left a will, the executor left a will, and for the other one, there was no will. So that distribution, therefore, where there is no will, is in accordance with the family arrangement, with what the family members have agreed or what they think. That's how the distribution is done, but it must be done. So here in execution, the executor must do exactly as the will states. That's the difference. But they all do the same things. They are going to distribute the estate or the property of a deceased person. Let me also tell you something. An estate, the property of a deceased person in law is called an estate. not these housing estates or what. No, it's called an estate. And so how you deal with that estate, how you plan for it, it's what we call estate planning. And and yeah, you have heard of estate planning lawyers. Some of you can start asking, are you a family lawyer? Are you an estate planning lawyer? Yes. So those lawyers. Therefore, a will, ladies and gentlemen, by the way, a will can be done by a man or a woman. It's not only for men. And in that will, please indicate, you must indicate your children, you must indicate your property, you must indicate who you are, what your names, your descent, or your where you come from, father, mother, people of this area, blah blah, and so how you want that property to be distributed and to whom. So the will makes things very, very systematic. It simplifies life for the people that you leave behind. So I encourage you, ladies and gentlemen, to do wills, do wills, do wills, and do wills. What about if someone dies without a will? Now, if you die without a will, your family will have to sit and choose one or more people who are going to be responsible for your property. By the way, if you do not leave property behind, there's no reason for you to listen to this podcast. In fact, there is no reason for someone to get letters of administration for you. In fact, the court will not grant letters of administration for a person who dies without a will and without leaving property. Nothing. So, for starters, for you to get letters of administration, you must know or be sure that the deceased person, the person who died, left property. Now, you die without a will. The family will sit in a meeting, minutes properly taken down, and choose whom they want to become an administrator or administrators. I have said an administrator can be one, or they can be 2 or 3 or 4 or 6, depending on what the family chooses. So there's going to be a family meeting, minutes properly taken. Then you go to the LC. The LC will know that, will have to be notified that this family of Mr. Kafero chose Kevin to be the administrator. Now, Kevin has to go through that process. So from there, they'll, together with the minutes and the letter, they will go to the district, the cow, LC3. So when they go to the cow will hold a meeting, the family meeting. And that family meeting, they will confirm to the cow that Kafero died of this, was a resident of this, left property ABCD, left children ABCD, left a dependent relative, left these beneficiaries, and we have decided that Kevin is going to be or should be appointed as the administrator. Now, it is not the family that appoints an administrator, it is not the cow, it's not the LC1, it's not the administrator general. All those guys all those offices are getting a person recommended. Who appoints an administrator is court. Let's complete the process. So we are at the cow. The family meeting is done. The minutes are recorded properly. Recorded, people sign, person appointed or confirmed to the cow signs, stamps. You go to the Administrator General's office. Why do we go to the Administrator General's office? We go to the Administrator General's office because 1, that is the law. 2, because the Administrator General is the office, is the representative of government responsible for the properties of deceased people. The same way you see police being responsible for crimes and keeping law and order. So that is the office responsible for that. So you go there together with all of the family goes there. You present yourself and you present the person that you want to be appointed as an administrator, or the people that you want to be appointed as administrators for the estate of Mr. Kafere in this case. So the Administrator General will make inquiries. I'm sure those of you have been to Amamo House where the office is, or to the districts where the offices used to be, you've seen those meetings. So he or she makes those inquiries Are you sure? Are you a beneficiary? Are you a son, a grandchild? Are you this? So when the Administrator General is satisfied that this person should be given letters of administration, they will issue what we call a certificate of no objection. Now, together with those minutes from family minutes, LC1 letter, cow, and certificate of no objection, and the minutes at the Administrator General's office, because while you're meeting at the Administrator General's office, there is going to be minutes recorded, minutes taken down. So those minutes together with that file, you now go to court and file what we call a petition for letters of administration. So you can clearly see the process without a will, person dying without a will, is longer. Ladies and gentlemen, there's quite a lot for us to talk about, but time has never been our ally. Thank you for watching. Next episode, we're going to talk about the landlord and tenant. Keep it here. See you then.